moving on, non-compete agreements. I thought we were going to have a lot to talk about here. I thought we were really going to be able to go down a nice, fun discussion about how all the rights have been taken away. But despite the fact that the Federal Trade Commission went through a lot of work and a lot of effort to put together a really, really thick, like 300 plus page decision and rule on this, some court down in Texas decided to say, nah, never mind. Don't worry about that rule. You're okay. Keep on doing what you're doing. And so we'll see as that case goes down. But the Federal Trade Commission made a rule that said, look, for most part, we believe that non-compete agreements are unlawful with very, very rare exceptions, which we don't have to get into the exceptions right now because there's no rule. The rule went into a court and the court decided to make an injunction nationally right now against that rule. It'll go through the appellate process and we'll see. It'll take some time to go through this process. But right now, we don't have a federal rule that says from the Federal Trade Commission that it's unlawful. But there are some concerns. First of all, in Michigan, non-compete agreements are lawful. You can enforce it. You can draft them and you can make them so long as they're reasonable in time and scope. In other words, you can't say, you come work for me at my new hamburger stand. And because I'm going to teach you all the secrets of how I make my sauce and how I chop my onions and I put the patty on the grill at just the right time, you can't work in any food industry anywhere in the world because, my one standalone stand will be hurt by that. And you can't do it for the rest of your life. That's too long. That's too much. You can't do that. Reasonable in time. And you'll see non-compete agreements that go for a year. They're generally enforceable. You see them that go for 2 years. Okay, you're getting on the edge of it, right? There's even been cases where there have been 3 years, but it's, exceptional circumstances. So you go for a year, you're safe. You go for more than a year, okay, you're in kind of a gray area. You're probably okay. But once you get past that 18 month, you're probably gonna get yourself in trouble. Geographical area. Is it too broad in geography? Again, look at what you do. What did the person do? So let's take a look at what your business model is. If you work in one county and one county only, and you make it a statewide prohibition, well, we usually try to draft those so that the court can say, well, maybe the state's too broad. Go ahead and reword it so that it's just in the place that's actually helping you. Okay. Maybe you say, I want to grow, I'm advertising. There could be changes in what I just said based on what's a reasonable restriction. Where are you advertising? So when we draft these things and when we enforce them, because I think Mike and I have talked about this along with Tony, we have enforced and had more cases since the beginning of COVID than I think in the 20 years before that combined. Everybody wants to enforce a non-compete and everybody wants to go to work somewhere else, maybe because of the market, maybe because people said I can't have it, so I have to have it now. I don't know what it is. Whatever it is, people want these things. What we've seen, however, is we've seen movement in these things in defenses. It's difficult to defeat a non-compete that's drafted and tailored properly in the state of Michigan. If you go into a regular court and it's well done, that's fine. But I have seen judges who won't give you an injunction and they won't allow you to just stop the person right away saying, hey, I don't see anything that's a problem. If you win, you'll get your money at the end of the day. How much money are you entitled to as a company for enforcing these? Well, that's up to the particular facts of what you have. The higher a person is up in your chain, the more access to information that they have, the more likely it is you're protecting a legitimate reason and legitimate business interest. If you're not trying to protect a legitimate business and you just want to stop somebody from going out to work to be, spiteful, that could be a problem that you have to answer to a court, and it could go to a jury. And the jury might say it's not fair. This is a person of minimum wage, at-will employee, and that's it. But you can enforce a non-compete agreement that's signed by an employee for the continuation of their at-will employment as of right now. So that's something we have to keep in mind for employees and for employers. And there's a difference between non-compete and non-solicitation. If you ever heard the word non-solicitation, they are different. A lot of times we put both of them into an agreement that'll also have a confidentiality provision that says, look, anything you learned here from us, anything you get from us, you have to keep that. And that can actually be forever, right? In most situations, right? You can't give unless you know about it publicly, right? Unless it's something that's public. The non-solicitation means you're not going to come after our customers. That's what a non-solicitation agreement is. You're not going to come after our employees when you leave. So you define who your customers are and you define who your employees are and you try to stop them. So what you're trying to do when you have these agreements most of the time is stop people from taking your information, stop people from stealing your employees and your customers, and stop them from going over to the person next door and taking the secret sauce or whatever information they have and competing in a manner that's non-competitive, that actually gives them a benefit without the money. And Michigan's got certain statutes on this to help protect that. If an employee jumps ship and goes from one company to another, one of the ways you can enforce it is against the employee, but you can also, if the company knows about it and they still continue to employ the person, you could sue both the employee and the company that hired that person and go after both of them. So there are ways that we can enforce these things in Michigan. So we have to take a look at it. Is it, what's the reasonableness? What's the scope? What's the time? Who are we trying to enforce this against? Because sometimes, there's a question of, well, the customer wanted to come to me. I didn't want them. I left and they came to me. And I had a non-solicitation provision. And there are some laws out there that we can go through, and it all depends on facts, because there are some situations where it depends on the language of the non-compete agreement. So you want to look at that, make sure it's up to date, make sure it's state of the art, make sure we got all the things that comply with the current state of the law. Now, let's move forward to what's going on the bigger picture. We talked about the FTC got overruled. The National Labor Relations Board, however, is making decisions that says, listen, these overly broad confidentiality agreements say I'm not going to talk about anything that I found while I'm there. That actually could be an unfair labor practice to maintain or make somebody sign one of those. Mike just talked about a lot of those things that the NLRB is doing. They're going after not just union shops, but non-union shops to say overly broad confidentiality agreements are unlawful. The same thing goes to, I'm not going to talk badly about my employer, right? I'm not going to say anything bad. I won't disparage. They're saying, hey, that's so broad. I can't talk bad about how bad they are to their employees. And that's a violation of the National Labor Relations Act. And they're also saying potentially you could get an unfair labor practice on a non-compete. So a person could come into the National Labor Relations office and say, hey, my employer is trying to stop me from competing. And now the NLRB is taking the position that they're going to start trying to say that in and of itself is a restraint of Section 7 under the National Labor Relations Act. So not only can you sue somebody to say, hey, that's a tortious interference with my business interest to go out and get a job and your non-compete's too broad, but I'm going to run down to the NLRB separately and I'm going to file a charge against you and have the government investigate you as well. So it's just something that could happen down there. We see the NLRB now has put out memos saying they want to attack those things. So it's not all the agencies. We see other states enacting laws that are saying, look, maybe we should do this on what they call a means test. In other words, the more you make, the more likely it is that you can enforce these things. The less you make, it's like, well, why are you restraining somebody to go from, a low-paying job that you don't have any real secret information that you can give away into another job? And you say California's never really had non-competes. They've always just protected the non-solicit and the confidentiality provisions. If drafted properly, they can protect your business just as well. So we have to make sure when we do things, we don't just go real quick to, hey, I got a non-compete agreement. When you look at it, it's actually non-solicit and it's not very well written. Or I got a non-compete. Well, no, it's actually a confidentiality provision and it's so broad you might get yourself in trouble or might get struck down. So what we're looking at now is we don't have a state law that prohibits it, but that could change as well. There have been efforts to try to prohibit this at the state level. We're going to have to keep an eye on it come 2025. I don't think there's anything between now and the election that's going to happen. But after the election's over, there may be some interest in trying to engage in a non-competition law. We've had laws that have been proposed in the past, and they were more on that means testing. If you make over so much money, say $70,000, $75,000, they're enforceable. Below that, maybe they're not, unless it's a sale of a company or something of that nature. So we have to keep an eye on this. It's a developing area. The FTC's rule's gone now. At least it's enjoined for now. We'll have to come back later. It was a very interesting case. But you can enforce these now in a courtroom in Michigan. But if you have somebody who works outside the state of Michigan, I'd be very careful with it because some states are making these unlawful and a person can countersue you for tortious interference with their ability to go get a job and business interests. So I think that's what we have to do. We have to be very careful with these things. They all run together. A lot of these laws have different components with different agencies. The NLRB, along with the Federal Trade Commission, have signed memos to try to share information. So a person can still try to say, you're restraining my trade based on certain facts and try to go to the FTC. They can go to the NLRB, or they can try to fight it in court and say, I think it's too broad. So with that, I think hopefully everybody understands what I'm trying to say to you is we have to continue to look at our rules, look at our policies, make sure they're up to date, and make sure they're enforceable. We don't want bad policies that are signed that we can't enforce. Don't make them too broad.